All right, if there's no other questions about or comments about dispositive motions, the final topic for the day is trials. And we're not by any stretch trying to create a trial practice seminar here. We don't have the time, but when we asked earlier, I don't think anybody has tried a case in the room and in the audience in federal court. So I guess we'd be curious, Judge Dean, as to your advice or comments about trying your first case in federal court.
Don't throw up. It's okay. It's fun. I think trial work is the best work there is, actually. So I think it's really important to figure out where you're trying the case, the logistics of trying the case physically. All right, you'll talk all about, trial practice kind of things. Let me talk about little practical things. We have two sizes of courtrooms in the federal court. There's a magistrate judge size, which is normal, and then there's the district judge size, which is abnormally large. But we try, both of them, in my view, are clumsy. Though Justice Breyer helped design them, so we all say they're beautiful. Okay. Is this being recorded?
It's on the web, but it's not recorded.
Oh, no, goodness. All right. Physically, they're funny rooms. I think this is true anywhere. And the state court, every courtroom is different, right? So the sight lines are weird. Where you put yourself, where you can hear, the acoustics are different in all courtrooms. I think that you need to go ahead of time before you try your first case and just spend some time in that courtroom and figure out where you're going to be, because there is nothing worse than all of a sudden not knowing where to put yourself. And I think if you're not comfortable physically, then it throws you, you can have all the most brilliant questions in the world, but it's just disorienting. So I would make sure that you know where you are, where do you stand, what's the norm for that courtroom. A lot of the district judges in federal court give time limits on civil trials because they have a big criminal docket, and the criminal docket has speedy trial considerations, which means they have to be tried within a certain time. If that's the district judge's practice, you need to know that. You will know it, they'll tell you, but you really need to, it's another factor to consider in trying a case. I don't know any magistrate judge that actually does time limits, so think about consenting to trial before a magistrate judge. But it is a difference, and it is something that's important, and they each do it differently. Some of them will ask you to time certain witnesses, and some of them will say you have 7 hours to do whatever. Have you tried with time limits? Have any of you? That's like my nightmare, I have to say.
I have not with time limits.
Tried the case myself, but have been part of trial teams with trial limits, with time limits, and it's harrowing and requires a tremendous amount of planning and preparation. I've seen one case I'm thinking about in particular where one side burned an enormous amount of time very early. We're attempting to put on a counterclaim, and we're literally putting witnesses on for 2 minutes at a time, where they would ask 3 questions that were necessary to establish the facts of their claim, but the witness didn't have, not really able to connect with the jury when you're on for 2 minutes and answering 3 questions, yes or no. So it does require a tremendous amount of planning.
So they just started with trials, and I was explaining how the district judges use time limits and the magistrate judges are really nice.
I don't use time limits. It's cold out there, by the way.
Yeah. So they just got started on
Okay.
Do you use time limits?
Nope.
Okay.
Well, I don't like chess clocks, things like that. I don't like picking some arbitrary number. You have 17.4 hours of trial time. I don't know how you can do that fairly. I have had situations where the lawyers will say, well, this case will take a week to try. And I say, well, let's tell the jury 2 weeks just to be sure. And then on Wednesday, they say, we're 3 weeks behind. And it's like, hold it. Christmas is, we can't do this. It's not going to work. I have a trial after this one. And sometimes I have clamped down. As the trial has progressed, I will lean harder and harder on people and trying to make sure I'm not being unfair to the defense, which of course goes second. But I don't like the arbitrariness of just saying we're going to fit it into this period of time. On the other hand, if you tell me it's going to take a week, come on, let's get it done in a week.
Yeah.
I was just going to add the comment that we had a time trial before Judge Young in the spring, and to your point about the importance of preparation and short witnesses, whatever, the other side had to just can a huge list of witnesses because there just wasn't time for it. So you really have to do a lot of advanced planning.
The comment was how important it is to plan your time if you have time limits, so you don't, it's like those cooking shows, when they say jump back, that's it, you're done.
You have to plan accordingly, but you also have to stick to the plan, because it's tempting when you're in the first day, your cross-examiner is running along and you've allocated an hour. If you go an hour and a half or 2 hours, it's going to cause problems, and you think you're fine, you can make it up later, but you really need to stick to your plan. Otherwise, you end up with 2-minute cross-exams or just not being permitted to cross-examine witnesses.
When I became a judge, I guess I was surprised that this was the biggest point of conflict, was the expectations of the lawyers and the court in terms of time, where the lawyers sometimes seem to think we are kind of an unlimited resource, which we're not. It's me, or Jude. Not only is not unlimited, it's one human being and 52 weeks of the year, and it's not even that, of course. And you really have to pay attention to this. You really do.
Did you have any other comments about trials, Judge Dean?
Well, you want to talk about things that work, things that don't work?
In trials, sure.
We're talking about trials right now in our program, but
Yep.
we're also open to hear anything you want to hear. You had mentioned you had some thoughts on what lawyers do well and not so well.
Careful, don't just give me the mic here. I won't stop talking. But
I'll interrupt them because I'm not afraid of them.
I guess what I'd like to start with is this. You probably talked about depositions. When I was a lawyer, of course, I took a lot of depositions, sat through a lot of depositions, read other people's deposition transcripts. Almost never when people are taking depositions are they thinking about the trial. What is this going to look like? And in fact, the mindset is often, what nuggets can I get that I can use in summary judgment? And that can be very problematic if the case actually does make it to trial. At the risk of telling you something you don't already know, depositions really have 3 basic functions. One is discovery. Tell me what happened. What happened at the meeting? So-and-so. And then you lock the person in. Function number 2, have you told me everything that happened at the meeting or everything you remember? Yes. And function number 3 is cross-examination. So John Jones was not at the meeting. And you go back and forth. You ask open-ended questions, lock it in, cross-examine, and so forth. Well, people skip the discovery part of it, and they just cross-examine. And so you start to have conflicts, even at summary judgment, but at trial about, well, you didn't ask me this topic. You're saying this for the first time. Well, that's because you never asked me. If you go to impeach someone with a prior inconsistent statement or try to impeach someone, chances are pretty good, if you aren't thinking about it, that your question does not read cleanly. Like, what color was the traffic light? It was red. You're reading like this from a stack of documents. So insofar as we've been discussing the color of the traffic light, strike that. Well, with regard to the color, you have this tangled question, and the witness says, well, I don't know if I'd really call it red. It was sort of between orange and purple. You get these nonsensical answers. And again, if you're thinking ahead to the trial and thinking about, do I care about this statement? Do I want to lock this person in? Might I have to impeach this person later if they try to change the story? Just say, okay, let me get it straight. What color was the traffic light? It was red. Boom. And that's, the Q&A you want. I get deposition designations before trials sometimes, and just like, oh my God, I'm reading, pages and pages of lawyers talking and long rambling questions. Sometimes they forget to ask the guy what he does for a living. Like, who is this person? Why am I reading this? Because no one ever thought to ask the basic questions, kind of the setup. This is who this person is, why they were involved, et cetera, and then what happened in the meeting in Chicago. So I guess that's my first point is even if, only 0.1% of these things are going to go to trial, you have to think about trial from day one. You have to think about, what is this going to look like? What is the other side going to say? And if this is a witness I care about, how can I lock in what they have to say neatly and cleanly so that I can later use it and impeach someone, so that you can stand up triumphantly in the court. Remember, I asked you, what color was the traffic light? And you said, under oath, the same oath, the whole thing. You want it to be neat and clean, not festooned with words.
I agree. There you go.
Okay.
But it's also important when you try to impeach somebody that it's really an impeachment. Slightly off doesn't work. And people very often get caught up in it's not exactly the same words as they used at their deposition, so you do this dramatic thing, and then the jury's looking at you going, okay, I'm not getting where you are.
Sometimes I'll look at the jury as the impeachment starts for the 17th time, and you can just see the look on their face, like they're looking at me like, can you make this stop? They see the lawyer picking up the transcript.
And in your notes, you should know exactly in the transcript what page it is. It's a hard question to say, do you remember me asking you, as opposed to saying, I asked you at your deposition, so-and-so, and you give them the deposition, so they can't say, I don't remember. You just get sort of tangled up on, are they remembering what you did at the deposition, or what are you doing with their actual factual testimony?
Here's a good rule of thumb. Never ask a witness ever, do you remember anything? They're testifying from memory, right? What else would they be testifying about? It's just they're wasted words. It seems to invite people to say, do I remember?
Yeah.
Just ask.
What color was the light?
Yeah.
At your deposition, you testified X, Y, and Z. Or at your deposition, I asked you, and you can have them read the question or whatever it is. But I think what Judge Saylor is saying is so incredibly important. When you take the deposition, it is the different stages. You get the big answer, and then you narrow it down, and then you narrow it down, and then you have the key line. So you have all of the information, and then you have the points that you need to impeach and to make sure that they're committed to.
Something Judge Dean said, about putting it in your notebook, I think is critically important. I sometimes have the impression that it never occurred to the lawyer that this case was going to be tried. They're making up their questions on the spot. They can't find the documents or the deposition references. Imagine if after, let's say after Monday night's loss to the Dolphins, somebody asked, Bill Belichick or Josh McDaniels, so what was the plan? Oh, we didn't really have a plan. We just thought we'd make it up, as we went along, and we didn't really have any plays thought out. We just thought we'd go with the flow. Lawyers say things like this. I mean, they really do.
That's not how you play football?
No. I thought I was making a universal reference here.
I thought they just run around the field a lot.
Anyway, you just need to prepare. My view is you need to write out everything. You need to write out your questions, what you expect the answer to be, the cross-reference to the deposition, what it is in Exhibit 33, that you can use if the witness goes. It all has to be there, and it's a lot of work. Maybe that's why people don't do it. It's work. But you need to do all of that to get it down to a smooth, neat, polished presentation in court, and it's remarkable to me, anyway, how much time is wasted because either people aren't prepared or they aren't thinking about presenting things neatly and cleanly. If you're a judge, you're drowning in words. People, they file millions and millions of words come across my desk, metaphorically speaking. If I read things and the first sentence is, Plaintiff XYZ Corporation, hereinafter XYZ or XYZ Corp. Or the plaintiff by and through its attorneys, John Jones of Smith. Inwardly, I'm groaning like, oh boy, we've got 3 lines of text here just to get the name of the plaintiff. Here we go. And it happens in court, too. And we all have limited time, limited attention spans. We all want to get to the point. Maybe I'm not getting to the point here, but you need to get rid of the noise. You need to and the way to do that is to think about it in advance and to polish it, get it down to what you really care about and how you can give that the maximum impact. whether it's an oral argument or a trial or anything else. Eliminate noise, eliminate all the extra words, all the nonsense. I teach trial advocacy, and I'll say to my students, which do you think sounds better? Your Honor, at this time, the defense offers into evidence what's been previously marked in this proceeding as Exhibit 17 for inclusion in the record in this case. That's option 1. Or, Your Honor, I offer this as Exhibit 17. What does 1 do that 2 doesn't accomplish? But you have to think about that. You have to think about, what are these extra words? How do I get rid of all this stuff that's these vines, so to speak, that are cluttering up my presentations? And, it's hard. But it starts with thinking about it. Don't just stand up and say stuff. Think about, what am I going to say?
On just one more thing on use of a deposition at trial, the most effective thing I ever saw was, and they were using the deposition, and it had been videoed, and they did not only the video deposition, but they had the transcript underneath it. And that really, because listening to a deposition is deadly at a trial. It just is, whether you read it, whether you watch it, whatever you're doing, it's just deadly. But that, having both the visual and the words, really was incredibly effective. And it went on for like 5 minutes until the other side finally said, I object. I said, would you object? Like, why? They're saying everything twice. I said, no, it doesn't work that way. It's like being effective is not an objection. But I think you do need to think about how you want to present it at trial.
I would just add the converse of what Judge Saylor just said is true. If you use a deposition effectively, it's incredibly effective in not just for that question, but for the remainder of the examination of the witness, where if you ask him a question, he gives an answer, and you then introduce the deposition transcript that has the exact same question where he gave a different answer. And even better, if you then play a video of him giving the exact same answer, you start getting the answers you want pretty quickly, because it's pretty embarrassing. And if he doesn't start giving the correct answers or the answers they gave before, it burns credibility very quickly for the witness and garners a lot of credibility for the examining.
I agree with that. It's so much more powerful if you're literally asking the identical question at trial because you asked it properly in the first place.
And that's when we're putting together large trial examination outlines. That's what we do. We look at the deposition transcript and model our question. This is true, correct, whatever the statement the person gave. Just, the light was red, correct? And then if he says no, you go to the transcript and the person says the light was red.
Can I ask you how you handle exhibits? Like, what do you do when they come in and there's pre-marked exhibits 1 through 4,000, but they're really only using 10 during the trial? Seriously, I mean, and that's common because everybody wants to make sure that there's not an objection to an exhibit, so that you tend to be over-inclusive on the ones that you're agreeing to.
Here's my standard practice. You can designate or even mark anything you want. If you're afraid that I'm going to exclude it if it isn't on the list, okay, fine. Don't introduce something unless you want people to read it or care about it. Every single thing you do, every document you introduce takes away a little bit from every other document. Pick your spots. And I don't care what numbers the documents have. I don't care whether they come in numerical order or not. If you've marked 4,000 exhibits and you're only going to use 52, that's fine with me. And I don't care if the first exhibit's 238. The jury, by the way, when they hear exhibit 238 is going to go like, oh. Jurors are not masochistic as a general rule. They don't like this stuff. But I don't care. What matters to me is what you're actually going to do. And by the way, sometimes you need documents that nobody really cares about. It happens, particularly in business disputes. But most of the time, introduce it only if you want people to read it. Don't just leave it on the table. Just don't let it stack up. No one's ever going to look at it. If you don't show it to them, who will?
And I want to... I never know what to do, actually. So sometimes I feel like if there's only 10 exhibits, then I give the jury the list of the numbers. These are the ones that were referred to or whatever. Or sometimes If it really is only going to be a few, I have them reintroduce them as number 1, 2, 3. I don't know. It varies with trials, but that's something that you should talk about with the other side on how you're dealing with it, and make sure that if you are introducing all the exhibits, if they're undisputed and you do want them as part of the record, the fact that you've agreed doesn't make it part of the record. You have to actually stand up and say, I'm introducing these
Yes.
as exhibits, because otherwise they're not part of the record. But numbering is always amazing to me.
You've probably heard this joke about the perfect document request. Item 1, produce all the documents you were not happy to find. Number 2, produce all the documents you were happy to find. You know, it's kind of like that. The exhibits that matter really are the ones that you're happy about. I mean, sometimes you need to do a little bit more, but you know, in the modern world, because we're drowning in documents, there's kind of a natural tendency to use them. So, you know, back in the days of yore, if there was a meeting in Chicago, you'd say, was there a meeting in Chicago? Well, now you have emails. The email proposing the meeting, the email agreeing to the meeting, the, you know, ordering the donuts and coffee for the meeting, and on and on and on. And so people use them. They mark them. You know, sometimes they offer them, and it's hard to get people out of that mindset to just say, just ask. It's one thing if he disputes you that there was no meeting or there weren't any donuts, then now you have something to work with, but just ask the question.
If you do use emails, though, excerpting out of email chains, I find the jury goes crazy, right? Like, they want to know what's around it. And make sure that the jury has time to read. If you're using any document that you're flashing at them, or especially if you're flashing a highlighted part, I think the jury wants to know that they're not being duped. I mean, I just finished a trial, and the one comment afterwards was, why couldn't they let us see what was going on here? Because they kept flashing up like parts of an email, and the jury felt like they never had just a minute to put it in context. Yep.
When you say flashing, you mean on the electronic?
They used electronics, they used the Oscar, you know, so it was projected. Sometimes it's actually more effective to just blow it up and put it on the easel and have it stand there for a while. Sometimes the high-tech is helpful and sometimes it's not. I think you have to decide how comfortable you are with it and what you're using it for.
Yeah, actually, I'm sorry. Go
Yeah,
ahead.
No.
Let's
the
talk about that,
electronics.
because there are a lot of good things about low-tech. Let's take blowing something up and putting it on an easel. It sits there, and everybody can look at it, and they can go back and forth, particularly things like charts, maps, diagrams, or whatever. It's great to have it there kind of in the background for long periods of time. I feel that the single best way to present documents, as a rule, is in a 3-ring binder. It's technically quite difficult. The jury can't see anything until it's actually come in and so on. But a juror can read it at his or her own pace. Each person has their own copy. They can flip back, you know, to something if they want to check. Jurors complain to me all the time that lawyers use too many documents and put them up and down too quickly. The document camera has the advantage of spontaneity, which is, you know, great. Using the software, the document presentation stuff has bells and whistles. You can highlight things, you can just juxtapose them and so forth. Of course, sometimes it doesn't work, which is a problem. But, you know, you should think about all of these different things. It's a mix of different ways of presenting documents. I guess I've mentioned the big 4: easels, notebooks, document camera, electronics. Don't stand there holding the document shaking in your hand. Don't pass it from juror to juror, because either they won't read it or they will read it and then they're not paying attention to whatever else is going on. One advantage of the easel, back when I was an assistant U.S. attorney, our budget for a case might be like $50, some absurdly low number. And we would pick like the 6 documents we cared about, and because that's all we could afford to blow up, and it's actually not a bad discipline at all. You had to say, what do I really care about? What do I want to make sure they see and understand?
The other thing, if we're talking about easels, feel free to write on paper.
Yeah.
I just finished a 2.5-week trial that was in such need of a chronology. It was just in such desperate need of a chronology. And both lawyers kept jumping back and forth to the same items, and the dates were actually important. And I just wanted to say, so write down the date and what happened, and use it as a chalk, and then put the next thing, after the witness testifies to it, and it would have been so much easier. So that's my new thing, chronologies. I mean, the jury doesn't know the story, and the story doesn't tend to come in sequence. So you need to anchor people and tell them what to follow. So you can write, you can have the witness write, or you can make a chalk that says, here's, the critical events. Once you've had the testimony, here are the critical events, and it can sit up there. And you can keep referring, did you have the meeting before or after you sent this letter? As opposed to each time you're doing it. Now, is this the letter that was Exhibit 6?
Never use the words before and after, by the way, it's a law. You have to use prior and subsequent. So that even the educated jurors have to, okay, subsequent, that means after. Got it.
Is that like we have affirm, overruled, and what that means on the desk, sustained and overruled? You got to remember what it means.
I strongly agree with that. I think just about every trial would benefit from a chronology, charts, maps. It's so much easier to understand things if it's laid out. I've had suppression hearings where it's just a couple of police officers or whatever testifying, and they're exiting their vehicle and proceeding southwesterly and then turning and proceeding northeasterly, and it's like, does anybody have a map? And if not, can someone just go on Google Maps and just print it out so I can follow this? It's hard if you weren't there. It's hard.
And distance.
Yeah.
I have no idea what distance. Like when you're jogging, I don't actually know what happens when you jog, but I have a Fitbit, so I know how long I walk. But I don't have any sense of distance. You need to put things like that in context. If that's important, if you have an accident and it's 100 yards, I need to know what that means.
Graphs are good, particularly if you're dealing with business disputes and numbers, trying to point things out. I read a fascinating article a while ago that they'd ask a number of men and women different factual questions, like 100 of them, and the greatest disparity where men knew the answer and women didn't was how far the Earth is from the sun, which is 93 million miles. And men, like an amazingly high percentage of men, an amazingly low percentage of women know that fact. Who knows why? Why evolution has got us to this point, I couldn't tell you. But the point is, like, if you're trying to compare 93 million miles to the distance to the moon, circumference of the Earth, you need a graph or no one will understand. No one will understand the relationship of those numbers. Our minds are just not wired that way.
Probably has to do with which sex has more significant information in their brains than others. But we'll let that go.
You mean like the backup catchers of the American League, like the important things?
But I think what happens is we're so used to just using words, and we're so happy when we get the evidence in that it's like, okay, I proved that. And then you got to remember that people are sort of drowning in words and don't really know what to listen to. And you have to help them. And part of that is helping them with words, asking the question, the same question a couple of different ways to emphasize it and all of that. But the other part is visual. But it doesn't have to be bells and whistles. It just has to be something that you would like to read, that you would like to see, and that you could easily understand. And I think we talked a little bit about motion practice also, and it seems, I think that that's helpful for summary judgment motions or motions to dismiss, or some visual that says this is what I should be paying attention to is helpful.
Rule 1006 of the Rules of Evidence permits you to use summaries. You can use that. A big business dispute, you can summarize things. It actually comes in evidence as a summary. Very useful tool. As long as we're talking about pet peeves, can I change the subject?
Sure.
All right, leading questions. Leading on direct examination at trials and elsewhere is pandemic. It's astonishing what a high percentage of questions are leading. And I could speculate about the reasons for it, but whatever the reason is, it happens. I think some lawyers sometimes think that the goal is to try to get away with it if you can because you're under better control. But what happens when there's a lot of leading on direct, and I just finished a trial where it was astonishing how much leading there was, is first off, you're breaking the rules. You're not supposed to do it. You're making the judge work a whole lot harder because every improper question that is asked to a witness, my mind is racing. Okay, there's going to be an objection. What am I going to do with that objection? Should I say yay or nay? I'm also getting the impression either this lawyer doesn't really know what the rules are or is cutting corners. I better keep an eye on this lawyer. And it also makes the presentation worse. What winds up happening is the lawyer is kind of testifying and telling the story, not the witness. I think one of the reasons people lead on direct, they're not focusing on it, and because it's hard. You have to stop and think, how do I begin a question that begins with the letter W? Even if it's what happened next, you have to stop and think about that. It's easier to say, well, then the truck pulled out in front of you, right? Instead of asking the witness, what happened next? The truck pulled out in front of me. I don't know how to make this stop. Much of it is not objected to, but when I'm on panels like this, I point it out. My colleagues, I think, for the most part, share my view that there's way too much leading, that it's harmful to cases, and there's a peculiar phenomenon as well. As you may know, I issued a standing order encouraging inexperienced lawyers to participate in things in court, including in trials. And when I have a very junior associate handling a minor witness in a trial, the associate asks questions like this. What's your name? Where do you live? What did you do next? The lawyer who's been doing it for 40 years says, now, did there come a time when you had occasion to discuss with Mr. Jones the fact of your meeting? And like learned bad habits, I guess. Maybe that's the point I'm making. It's hard to be disciplined. It's easy to fall out of discipline. It's easy to learn bad habits, hard to learn good habits. If you're going to do this, be disciplined, do it right. It's the judge will appreciate it. The story will come out better, I think, more forcefully with the witness. And the trial will probably be a little bit faster as well because you're asking clean, simple, uncluttered questions that begin with the letter W.
I think it's incredibly important that the jury get to know who your witness is, and you really do lose all of that with leading questions. And no matter how fast you think you're moving the trial, the jury is just learning who you are. And you do
Yeah.
want your witness, unless they're really a disaster, which happens. But in general, the jury needs to feel that they know who's testifying and that the story is coming from the witness. Yep.
I just have a question where there are multiple parties, and sometimes on direct, there won't be leading questions, and then another party will cross-examine the witness. And then on redirect, another party that is kind of aligned in interest with the first party will try and rehabilitate the witness, but kind of using leading questions on redirect to decrease the impact of the cross that just happened. And I was just wondering how the court kind of would handle that situation, whether leading questions would be allowed.
All questions on redirect are leading. It may be the single weirdest thing about it. Even lawyers that know what they're doing ask leading questions on redirect, sometimes shockingly so. The lawyer who's done the cross has sat down, they've been hyped up, they've got the adrenaline, and they sit down and they're not really paying close attention. And the redirect lawyer stands up and says, now, you didn't really intend to hurt anyone, did you? You were just trying to do your job, right? And no one's objecting. But it's amazing how much leading there is on redirect.
It's called redirect for a reason. It's supposed to be direct
The rule's the same. If
questions.
it's an adverse witness, you can lead. If it's not, you can't. I mean, with certain exceptions,
So what do you do when the other side calls the other side's witness as their own? Do you let them lead?
Yes. And, I may sometimes need to lay a foundation that the person is genuinely adverse, but if it's plaintiff versus big corporation and they call CEO a big corporation, of course they can lead.
And then what do you do on the cross?
It's cross in name only.
And then it has to be more
Lead on
direct.
leading, yeah.
And do you have them call twice?
I will often give people the option because on the one hand, you don't want the plaintiff calling the adverse witness to dictate how your case is going to be presented, and so I'll let people defer. Now, it depends. Most people prefer not to defer. They prefer to get it done right then and there, but I'll give them the option.
So that's, what we're talking about is if you've called the other side as your witness, in general, witnesses don't want to testify twice. On the other hand, who's controlling the subject matter of how it's going in? And it is often a little weird when you've sort of done this cross-examination and then the other side gets to say, and so what's your name and what's your education and where have you been? And of course you've been on the stand for 2 days, but let's start from the beginning.
Yeah.
But I've seen it done well. I've seen it done like, okay, let's ignore all of that now. Who are you and why don't you tell your story? But those are things that you can talk to the court about. I just had a witness call twice in mine, which I don't usually do, but the subject matter was so different for what the plaintiff wanted to call the defendant for and what the defendant wanted to put in, that we decided ahead of time that it was better to just separate them and have them come in twice. But I let the defense not cross. I said you can hold that until your testimony. Does that make sense? So the plaintiff did an examination, and instead of the defendant crossing its own witness, they waited until their own case and then called him and did it on direct. But those are kinds of things that you need to straighten out and think about ahead of time.
By the way, the most efficient trial I ever had was a pro se plaintiff against a pro se defendant. Just had the plaintiff tell her story, and the defendant told his story, and that was that. It was very, very simple.
Yeah, but I had one that said, and where was I on the night of I was like, I don't know. It was really weird. All right, your next one. What's your next one?
I can keep going all day. All right, cross-examination. This may not be obvious, but the most effective cross-examinations, and really the point of cross-examinations, are ones that elicit facts. If you're just arguing your case, and of course you're always allowed some latitude to do a little bit of argumentative questioning, it's not really where you want to go. And the worst thing you can do, I think, is just repeat back the testimony that killed you in the first place in a sarcastic tone of voice. Your testimony is X, right? Your testimony is Y. Your testimony is, yes, that's exactly my testimony. This is a true story. Stop me if you've heard me say it before. Years ago, I'm representing a client who's in the grand jury in the courthouse in Boston. And there's two security guards out around the corner where I can hear them, and they're talking sports, and one of them says, I'm from Pittsburgh. It's the best sports town in the United States. So everybody knows the answer to that. No way, dude. It's Boston, man. Instead, the other security guard says, Pittsburgh, best sports town in the United States. They don't have a pro basketball team, do they, right? No NBA team? And I thought, wow, that's a pretty good question, isn't it? Best sports town, they can't support a basketball team? And the guy asked about 8 questions. The Pirates were last in attendance in baseball, and the hockey team went bankrupt twice. University of Pittsburgh doesn't draw particularly big crowds for football and so on. And finally gets to the Steelers. And he says, Steelers, there's no fans like the Steelers. Nobody loves their team the way Steelers fans love their team. And the guy says, yeah, maybe like the Cowboys in Dallas or the Packers in Green Bay. So we in like 8 questions, he went from the best sports town in the United States, and now it's one of the 3 best NFL, which it probably is, okay? Which is a perfect cross-examination. He elicited facts, right? What can the guy do but agree? Yes, we don't have a basketball team. Yes, the hockey team went bankrupt twice. That's a perfect cross-examination. You are eliciting facts that the other side has nothing to do but agree with you. An argument is like, oh, dude, Boston, man, it's got to be Boston, man. What are you talking about? That's an argument, okay? That doesn't convince anyone. Maybe you have a bias one way or the other and you agree or not, but that's not effective cross-examination. And I see that just, after a while, it's just like someone hitting you in the head with a hammer. And it's like, oh, okay. Look at my watch. How much more do we have to endure of this? Ask a factual question.
The problem is cross-examination is fun. So sometimes you get a little carried away.
Of course you do. And, maybe if you're cross-examining the Pittsburgh guy, maybe you twist the knife a little bit here and there. But
No, I think that's right, and I think you need to also pick your arguments, because, the jury doesn't remember all the facts that went in, they'll just remember what you hone in on. So you need to pick, you don't need to cross-examine on every single item. You need to pick the ones that you think are really important, and then just go for them, and then you need to sit down. I mean, and the hardest thing in the world is not to cross-examine, and sometimes that's appropriate. It's just really hard, though. It's really hard to just say, oh, my God, can I just let this go?
Suppose you have 3 big cross-examination points and 2 more kind of okay points and 17 minor points. If you go through all of those, nobody, including the judge, is going to remember like which ones matter by the time you're down to minor point number 17. You've got to leave it on the cutting room floor. You've got to take chances and make decisions. And that includes, frankly, looking your client in the eye and say, I know you care about this, but that's not what we need to do here. I know you think he lied, on this minor point. You got to trust me on this. It's just going to be clutter that's going to take away from our case. In fact, that's one of the hardest things to do, is to deal with your client when you're trying a case. It's particularly difficult in the government because your client might be an agency, and one of the phenomenon that we see all the time when the government is trying cases is you'll have an agency, it might be the EPA or the SEC or whatever, and everybody says, put this in, put that in, put this in, put that in, put this in, and nobody can really say no. No one really has the authority to say, we're not going to do it that way. And so you wind up with these bloated cases. It happens all the time. Anybody remember the trial of Rod Blagojevich, the guy with the hair who was governor of Illinois? They had like a 2-month RICO trial, and it ended in a mistrial, and they interviewed the jurors afterwards. One of them said something like, it's like they said, okay, here you go fly the space shuttle. We had no idea what was going on, didn't understand the facts. Somebody came in and turned it into like a week-long or 2-week trial, and he was convicted in about half an hour. That's how that's how cases ought to be tried, no matter how important they are. Even, the governor of Illinois, you can always strip it down. But it's hard to say no. It's hard to say no to your own client. That's the hardest person to say no to.
I want to switch to some written things. So it's incredible. You get the opportunity to present voir dire questions that you want the juror to be asked, and you do proposed jury instructions, but you also do verdict forms. And I find that people don't pay attention at all to any of the above. So, I get voir dire questions that don't mean anything, when there really are some issues that you should explore with jurors, and you need to think about it. It's your opportunity to have, to learn something about your potential jurors. But more importantly, the verdict questions, the special questions that we send to the jury, people don't pay attention to them at all. And I find that puzzling, because that's the most important thing in the world, is what you're asking the jury to decide. And you need to really pay attention to the written work. I think sometimes you get so caught up in the direct and cross, and you worry about all of those things, and then the paperwork becomes secondary. But it really is an opportunity, and you really do need to pay attention to them. So.
I agree with that. I mean, the jury is getting a piece of paper. It's going to ask them to make specific decisions. I would say more than half of closing arguments don't mention those questions at all, which is kind of odd. Question 1, did X happen? They're going to decide it. You might want to say something about it.
Or did they prove by did they prove by a preponderance of the evidence X? Like, do you want the jury to think about the burden of proof? Don't you want or do you want to say, did so-and-so win and does so-and-so lose? How much information do you want in the questions that go to the jury? What order do you want the jury to think about it if you have a multi-count case? Those are kinds of things that help describe, it informs the jury of how to address the issues in the case. And it's just really important. And I find that sort of the night before, all of a sudden, sort of everybody's waking up and saying, I wonder what questions they're going to answer, and I'm going to win or lose. And those are really important, so take an opportunity to spend some time on that.
And I would extend that to jury instructions. I think most lawyers give it very little thought, just print out the pattern instructions, which are generally speaking horrendous.
Incomprehensible.
And they don't tailor it very carefully. There's a pattern instruction, I think it's Devitt and Blackmar, that says, innocent misrecollection is a not uncommon occurrence. Everybody got that? My instruction says sometimes people don't remember things correctly, it says, but, they're just making mistakes. Anyway, sometimes, you can tailor the instructions to the evidence or to the point you want to emphasize. And it could make quite a difference depending on how you frame it. Again, they're hearing it from the judge. They're going to take it seriously. I give all the jurors, each individual juror, a written copy of the instructions. By the way, I am evangelical on this subject, so I'm going to stop and talk about it. I just instructed a jury about 3 weeks ago in a racketeering indictment where I had 54 pages of instructions in writing, where I had to go through all the different levels of homicide under Massachusetts law and all the different types of armed assault. And it was bad. There wasn't really anything I could do about it, but each juror had their own copy to read along as I read them aloud and to take back with them into the jury room. And those jurors who had never served before were astonished that the norm is not to get a copy of the instructions, even one, never mind 12. And they asked the obvious question, well, how would anyone ever follow this? And of course you can't. I mean, the social science on this is pretty predictable. Sometimes a couple orders of magnitude greater comprehension if the jurors have a written copy of the instructions. Lawyers don't pay any attention to this at all. Judges tend to do things the way they used to do them. In state court, this may be a problem. It requires some logistics, photocopying and stapling all of this and getting it, typed up. But, ask. If you want the jury to follow the instruction, if it matters, see if the judge will give it to him in writing. Why not? And by the way, of course, the lawyer has it in writing, both lawyers have it in writing, the judge has it in writing, the clerk has it in writing, the stenographer has it in writing. The only people who don't have it in writing are the people who need to apply it.
Well, that's
It's a
because we
wonderful
actually
system.
just want them to do the right thing and not follow whatever we're mumbling there. They're hard. I mean, that's one thing in the proposed instructions, and in deciding how many issues you actually want to go to the jury. Do you find that, at some point, you need to drop counts?
Yes.
Do you really need, I'm going to mess it up, but like assault and battery, you tend to get thrown in on excessive force cases or whatever. I'm asking
Discrimination
this.
cases have all this stuff about intentional interference with this and that, and
You're either going to win or lose.
Yeah.
At some point you need to decide, because the more counts you have, the more we have to instruct on it, and the more incomprehensible it becomes, by definition. I mean, negligence takes 5 pages to say. It just does. And so you really need to figure out, especially when you're at the point, you put in your case, now figure out what do you really want the jury to decide, and do they have to be instructed on all the counts? And I think that's a critical time. Has anybody had an experience doing their own jury selection, ask the voir dire questions, where the lawyers have been doing it?
In state court,
Yeah, have you done it?
yes.
What's it like?
Well, I did it on a civil rights violation case, right when about 2 years ago, and it was the news. It took us 3 days to get a jury. We went through about 280 jurors.
Chances of you getting that opportunity then are slight, but I haven't had any lawyers ask questions, have you?
I permit them at sidebar when the individual juror is there to follow up a little bit, but I want to maintain control. This has so many problems with it. In the South, I attended a jury impanelment years ago in a southern state, and the lawyers are asking questions like, can you think of any reason why a lovely young woman, through no fault of her own, is injured by a dangerous product of a big, wealthy corporation? I mean, these are the questions they're asking. And, whatever it does, it doesn't promote justice.
I think most of us do the same. The judge controls the question, but as each juror comes up, we allow some, either tell me what the question is if you have another question to ask, or we allow some questioning. But I am curious now if that's going to change, given that the state court has more questions. Also, the value of cases are always interesting to me now. In the state court, you can ask for specific damages for emotional distress and the like. I've never seen that happen. And I'm dying to know how people value those cases. But we'll have to attend a seminar.
I used to sit in Worcester, and the values are quite different in Worcester County. I think there'd be some egregious, horrible thing happened, and the jury would say, we fine for the plaintiff and we award $4,900,
But you never want kids on the jury if you want a lot of money. Like, they're always like, wow, they got $500. What do you guys like, trying or not trying? What works for you? What do judges do that make you crazy?
Oh, here we go.
Now, there's a loaded question.
Other judges.
Not us.
Not about what makes the judges crazy, but as you mentioned, Judge, about, like an incomprehensible calculation by a juror or a jury, finding such small damages when it would seem throughout the course of the trial that, a lot of it wasn't even an issue. It wasn't disputed. Do you find that there's a difference in the federal court jury pool in either like qualitative or quantitative behavior? Is it substantially different from the state? Having not done a jury trial in federal court, but have done it state, is there some fundamental difference in the pool or in the way that they do things?
Well, there certainly is a difference in the demographics. We draw from all of eastern Massachusetts, east of Worcester County. And so compared to, let's say, Suffolk, it's going to be much more suburban and therefore tends to be, more educated, wealthier, what have you. Although I tried a case once in Suffolk years ago. Of the 12 jurors, 11 had, bachelor's degrees, and we had a couple masters and a PhD. I mean, even, Boston can have a highly educated jury. So I think there's that. The dollar amounts, I don't know, because there's so many moving parts to this. I had a trial within the last year or two. It was the police roughing up someone in a bar, and the juror very clearly thought the policeman had acted improperly and didn't like the plaintiff, who thought, he was malingering. And they found for the plaintiff and gave him $1,000, something like that. And to me, it was pretty clearly kind of a message to both sides. They don't really want to say fine for the defendant. They don't want to reward his behavior, but they don't really want to say to the plaintiff, okay, you've suffered $1 million worth of damages. It's kind of like, here you go, now go home.
But we don't have an editor.
No.
So we can't, in state court, the judge can do an editor or remitter. So I also had one where a prisoner was very badly beaten in a locked cell. I mean, and the jury found that the prison guards locked him in the cell with knowledge that this was not going to be good, and they awarded him $5,000, and his medicals were like $25,000. So, and I ordered a new trial on damages. I'd never done that before. So, in general, we don't have a reputation for being a high verdict. Actually, we have a reputation for being low verdict, but I don't know. It's been too many years since I've done the state court cases to really know the comparison, so I don't really know.
Historically, of the 50 United States, the 6 states with the lowest jury awards are the 6 New England states. And I think it's a combination of a whole bunch of things, cultural attitudes and so forth, but also not having elected judges, I think, makes a difference in what kind of cases go to trial and how the cases proceed once they're there. I think that makes a difference.
And then just the follow-up on, do you, after having done the voir dire of the jury members at sidebar with follow-ups, do you find that is, at that opportunity, are the lawyers able to really reveal either bias or whatever, does it make a difference, is what I'm saying? Once you get the people at sidebar, you figure things out, is it making a difference in verdicts?
I don't know enough to know. I think that deep down, I feel like a diverse population is probably the fairest jury you can get. I think the more you know about people, the more you're concerned about them. The more the people talk, it's like, the one person I did excuse that I'm sorry I excused was the psychic who told me that she knew what the answer was before. And I should have made her stay, but I excused her. I know there's a whole science out there of jury selection. I think that you have all these jury consultants. I think you have to know a lot about people, and then you're using all your biases to assume how people are going to react. So I think if we really want a fair jury, it's probably asking no questions unless you're related to anybody, and then you get a diverse population, you figure it out. I hope to get the most obvious biases out. I'm always amazed at the excuses that people have. And I'm always amazed that it's actually always both sides. Like, when I first started, I thought, people would be pro-police or pro-law enforcement in certain populations. And I find that there's an equal number of people with very strong feelings, both positive and negative. And I found that in virtually every case. And I don't know if people I don't know how much of it is trying to manipulate the system or not. I don't know. I mean, I just sat this case and they were passionate. This person gets up and tells me they can't possibly vote for a corporation. Like, really? This is like you lay awake at night and think, oh, corporation, they make me crazy. I don't know. So, when they keep going on about it, do I have to excuse them? I mean, at some point I have to excuse them, but I'm not sure if that's real.
This is a complicated and very human process. I think a shockingly high number of people just want to get out of jury duty, period, and are willing to say whatever they think they need to. And of course, I let them all go. If they say they're going to be biased, they're not going to be good jurors. I don't want them. It's just creating issues. I mean, I've said to people from time to time, if they expressed racial bias, for example, that they have to be ashamed of themselves, that they should go home and tell their children what they said to get out of jury duty, but get out of my courtroom, I don't want you on this jury. So you have those people. You have people who have genuine issues. Something I see a lot now in drug prosecutions is the people who, their brother died of an overdose last year and they have this emotional, reaction, and they can't serve. It's tough. I try to emphasize that what we want is jurors who are open-minded and fair, and press people on the point. I have to rely on what they say. I can't look inside their minds. I don't think it's a perfect system, but having said that, I feel like most of the time you can tell. You can tell if people are trying to be fair or not. And what fair means, might be different for different people or whatever, but let's put it this way, if you show up for jury duty at all and you don't give a stupid excuse to try to get out of it, that means you're in a category of people who take your civic obligations seriously enough that you've at least gotten to that point, and then we're kind of fine-tuning it from there. One more thought. There's some movement afoot to get rid of things like peremptories, like Judy says, well, let's just put the first 12 people, who aren't related to the parties in the box, and that'll be the jury. I think that would be a disaster.
I think that's not fair.
There are all kinds of times where someone winds up as one of those first 12 people and kind of everybody can tell that something is not right, or that they just aren't the right person for the jury. And, it's, you need some control over that.
I agree. I don't mean to say, I do think that the voir dire questions are incredibly important. But I don't know how much we actually learn about people, but we try. And I always seat 9 in the civil. What do you seat?
I now see 10. 9 is the midpoint between 6 and 12, and since there's good
And I don't
arguments.
want an even number for some reason, I don't know why.
6, well, it has to be unanimous in federal court, but 6 is too few. I think the decisions are more likely to be erratic. And I'm not convinced there's a difference between 12 and 10 such that it's worth the extra 2 people. But I do 10. You can see how scientifically I've thought of this. I do 10.
So in federal court, though, it has to be a unanimous verdict, which is different than the state court.
So do you have the ability to do a remitter? I know you can't do an honor.
Yes, but I believe, I haven't done it, but I believe when I looked it up, that was the answer. We could do a remitter, but we can't do it.
But we have to offer them,
We have to offer
there's some
them
wrinkle,
it.
new trial, or there's some wrinkle in this, that, like, either you accept this award, or it's going to be a new
Yeah.
trial. I went through this once.
We've been through it in a few cases at our firm, and this is where we actually did present a very, very detailed jury verdict, and it was clear that there was an error, that neither side had presented the damages were based on court records, and neither side had suggested the damages awarded by the jury were the correct ones, and there were calculation errors. And there, the court was able to correct it, essentially. Actually, the court gave the jury the opportunity to correct it. They corrected it once. Another flaw was identified. It was corrected, and then we went to a new trial. Anyway.
Years ago, I had a breach of contract case. I'll make up the numbers because I don't remember them. Plaintiff's lawyer, make sure he's not in the room, was not the most capable lawyer, but his client had good facts, and that's usually what matters. And the breach of contract was like $2 million. And the jury comes back with an award of like $8 million, which, and I just basically said, can we just agree that the maximum possible damages that this plaintiff can get is $2 million? It's like one count breach of contract. That's what they asked for. Do we need to go through this exercise? And they agreed, so.
That's one way to avoid the motion. Anything people agree to, we're really good on.
So we have about 5 minutes left. Does anyone have any questions from the floor for any of the panelists or the judges?
How many can't wait to try your first case in federal court? There you go.
We have one question from our web audience, and this
Yes.
goes back to a discussion we had earlier about summary judgment motions and partial summary judgment motions. So the question is, could you provide an example of when it might be a good idea to file a motion for partial summary judgment if you're still going to need a trial for the remainder of the issues?
Yeah, I feel, especially if I think the case is going to go to trial, I'm going to have to weed out this underbrush anyway. If there's a serious problem with counts 3 and 7, I'm either going to be dealing with it at sidebar at the conclusion of the plaintiff's case, or I can deal with it beforehand with a little bit of time to think. So I prefer it. I mean, I'd rather that counts 3 and 7 weren't brought in the first place, but if it's pretty clear that summary judgment should be granted, so let's just grant it and strip this case down.
I think you should think about if it's a count that requires additional evidence, and if by knocking out that count, you can eliminate some witnesses. I think that makes sense. And I also think multiple damage kind of claims, or attorneys, if there's a different damage element that might affect the voluntary resolution of the case. I would think about it that way. But the difference between assault and battery, or, wrongful touching or something, some of them are just not worth it. It's just going to be the same thing, and I think.
On the other hand, if you add, you have a count for abusive process, and it's pretty clear that's a whole set of jury instructions, it's a whole different theory. If the evidence doesn't support it, can't we just get rid of it and try the case on the assault and battery, or whatever it is that is really the issue here?
Yeah,
But- No, go ahead, but because it'll affect how the case goes in.
Yeah.
Yeah, I was going to say, if there's a statutory damages claim and an actual damages claim, if you cut out the statutory damages claim, it affects what the jury's going to have to decide and what your jury's instructions are going to be and everything else, and you might as well resolve that early before you have to amend the jury instructions or something at the end of the case.
You gave one example earlier of feedback jurors have given about lawyers, like they don't hold up the language
Yeah.
long enough to allow them to read. Have you received other feedback from
Yes.
jurors about lawyers, good
Yes.
and bad?
It's easier to give negative commentary than positive, because positive commentary is all the same, kind of they did a good job. The negative comments are all kind of variations on the same theme. The lawyers were disorganized. Why can't they get to the point? Why did it take so long? Why did they introduce so many exhibits? Can't you stop them with this whole deposition impeachment thing? It's all kind of the same thing. They talk too much and they don't get to the point.
Repetitive testimony, having the same witnesses sort of give the background of, so I was at this meeting and these 12 people were there, and you've now asked all 12 people, who else was at the meeting? That kind of thing. But my favorite was, we all have these stories, but where the witness, we had an expert who went on and on and on and on and on, and the jury said, told me afterwards, they said, once they told us what they were paid by the hour, we understood why he went on and on and on and on. So I think they're not unaware of what's going on in the courtroom, so.
Is there a question in the back?
Yes. Can you talk about how you would approach a fraudulent joinder argument when it's pretty clear that the plaintiff will eventually drop the only local defendant?
So, I'm sorry, a fraudulent joinder to create
Yeah, to create
a federal.
jurisdiction, diversity jurisdiction, where it's pretty
To create it as opposed to avoid it, because it's more typical. There's some pharmacy in Mississippi that's been sued 10,000 times or 100,000 times. They're trying to avoid federal court, that's it.
Right.
Is that what?
And the non-resident manufacturer is trying to get to federal court. Can you talk about how you would approach a situation like that? When it's pretty clear that the only local defendant will be dropped?
I mean, it kind of, each case depends on the facts. You can't grant the motion because it's obvious they're going to drop the case against the local defendant. You have to walk through the facts and the law. If it depends on state laws, it sometimes does, it can be quite tough to get a defendant dropped for fraudulent joinder. But I think the law is more pro-defendant now than it was 10 years ago. Can't remember the specifics, but I looked at this relatively recently.
It comes up in a motion to remand.
Yeah.
I mean, it's the context of how it usually comes up. I don't know what to say beyond that.
Can I make a completely random point on the motions to remand? Limited liability companies, LLCs, they are not corporations.
Right.
For diversity, they are treated like partnerships. They have members, not shareholders. It doesn't matter where they're incorporated because they're not incorporated. It doesn't matter where their principal place of business is. I issue, no exaggeration, 25 show cause orders a year on LLCs. Explain to me why this case in federal court, because you've treated it like a corporation and it's not, you have to show diversity. I've gotten rid of multiple cases over the years. I had, what we call Lloyds of London is these individual syndicates. I had a Lloyds of London syndicate that could not identify its membership and therefore could not establish diversity. But this is something that's driving me nuts, and I've got my colleagues worked up about it, so we're constantly, the whole court is issuing these show cause or limited liability companies, a very common way of doing business now. It's not a corporation.
And the most embarrassing case I had was the one that went up to the First Circuit on a diversity which nobody had raised, and the First Circuit said, there's no diversity, so we're not deciding this appeal. And you shouldn't have decided the case.
There's some case from like the Seventh Circuit or something, how bad would this be, where the appeals court said something like, it would have been a good thing if anyone had noticed before the 2-month trial that there was no federal jurisdiction and all of this was void.
And it is, as I said, as we talked about before, you cannot confer jurisdiction on the federal court. So if there's no jurisdiction, there's no jurisdiction. That's it, folks. So look.
Any other questions? All right. Well, thanks to Judge Dean and Judge Saylor,
Thank
and
you, guys.
Tasha and Chris, and thanks for everyone for coming this morning.
Thank you.